Hello, everyone. Good afternoon, and thank you very much for joining us at this HKIAC webinar, where we'll be looking at funding of arbitration claims and specifically on recovery of assets. My name is Brianna Young. I'm a Vice Chair of HKIAC and also a professional support consultant at Herbert Smith Freehills in Hong Kong. We are joined today by Omni Bridgeway in the form of Cheng-Yi Kong, who is an Associate Investment Manager for Omni based in Hong Kong. Cheng-Yi heads the Hong Kong office and is responsible for Omni's due diligence and managing their funded matters across Asia and EMEA. We're also joined by Marjolein van den Bosch, who is Head of Enforcement for Omni in Asia. Marjolein is responsible for strategic assessment and management of cross-border litigation, arbitration and enforcement activities, and her particular focus is Southeast Asia, and she is based in Omni's Singapore office. I don't want to spend any more time on introductions other than to cover a couple of housekeeping points which you'll all be familiar with. First, thank you all very much for joining us. We've had a really good registration turnout for this seminar, which we're delighted about, from a number of different places. So thank you in particular to those of you who have got up early or stayed at work late to join us. We will kick off with presentations. I'll start off with just a short introduction to third-party funding in Hong Kong and looking a little bit at what HKIAC has seen in the funding space so far. I'll then hand over to Cheng-Yi and then to Marjolein. You are, of course, welcome to ask questions at any stage. You are welcome to do that live by unmuting your lines and asking us. There's also the chat function via Zoom, so please do submit either way, the Q&A function via Zoom, and we will do our best to pick up as many of those questions as we can. And we will just encourage you, please, if you're not asking a question, to keep your line on mute for obvious reasons. Okay, so with all of that out of the way, I thought I would just kick off by reminding or introducing you to the third-party funding regime in Hong Kong, what the legislation looks like, the regulatory landscape, and a little bit about the rationale behind third-party funding here. So if we can move to the next slide. I know there will be a range of knowledge and expertise on the line. I can see that we've got a number of not only lawyers but funders on the line. So please, anyone is welcome to chip in with additions or corrections if needed. But just to give you, by way of background, a little bit of the context of third-party funding in Hong Kong. As I'm sure most of you will be aware, it's new for Hong Kong. Third-party funding for arbitration has been permitted only for about 18 months now. Up until, 2017, the state of the law in Hong Kong was not entirely clear as to whether or not it was permitted to obtain third-party funding for arbitration in Hong Kong. It's clearly prohibited for litigation in Hong Kong by the doctrine of champity and maintenance, that very old doctrine of common law doctrine that is now obsolete in many other common law jurisdictions, but persists here as both torts and criminal offences. So there was a clear need to clarify the law, particularly in respect of arbitration. There was also a desire to allow funding of arbitration claims for access to justice reasons, although arguably those are less important in the context of commercial arbitration. They are still relevant. It is still important for claimants to be able to bring commercial claims, even if for whatever reason they aren't able to fund those claims by themselves. As many of you will be aware, it's not only impecunious parties who seek third-party funding for their cases. It has emerged as an extremely effective way for any party to manage the financial risk of litigating, or in this case, arbitrating, and keeping the costs of arbitration off its balance sheet pending the outcome of the claim. And perhaps most importantly, from Hong Kong's point of view, Hong Kong has long been one of the leading arbitral seats, as you all know, in the world, and it was increasingly felt by the arbitration community in Hong Kong that we could not continue to compete as a seat if we couldn't offer funding in the way that London, Paris, and other seats, and by the time Hong Kong introduced its law, Singapore could offer. So those are the four key reasons why the Law Reform Commission started to consult on whether or not to introduce third-party funding for arbitration in Hong Kong. The result was a bill that was passed in 2017 and which took effect as part of the Arbitration Ordinance on the 1st of February 2019. And what Part 10A of the Arbitration Ordinance provides is that third-party funding is permitted for arbitration and proceedings related to arbitration. And that means emergency arbitrations, it means arbitration-related court proceedings in Hong Kong, and it may eventually extend to mediation proceedings, although that part was put on hold when the legislation came into effect. I'm not going to talk you through all of the relevant legislation, but just to hit a few of the key points. Funding can be provided in Hong Kong by a broad range of parties. Unlike, I believe, in Singapore, where it has to be a professional funder, in Hong Kong, there's no limitation on who can provide the funding, providing that they fulfill the criteria around things like minimum capital adequacy that we'll look at in a minute. It is mandatory for a funded party in a Hong Kong arbitration to disclose that it is funded and the name of the funder, but it's not mandatory to disclose the terms of the funding agreement. And having said that the definition of funder in Hong Kong is broad, the key exception is lawyers. And I mean all lawyers, regardless of whether they are qualified or practice in or outside of Hong Kong. Section 98(0) of the ordinance prevents lawyers from funding cases on which they are acting. As many of you will know, there is a prevalent view that that extends to lawyers providing services on any kind of success fee basis in Hong Kong. And the Law Reform Commission is currently looking at whether that needs to be changed and whether success fees should be introduced in Hong Kong. And we are hopeful that the law will change, but for the moment, lawyers cannot fund their own cases, either by providing third-party funding or success fees. Alongside the legislation, there was published a code of practice, a code of conduct, which also came into effect on the 1st of February 2019. And as you would expect, sort of similar to the ALF code of conduct in the UK and other similar regulation, the code of conduct establishes a broad set of standards for funders to comply with. One of the key ones is minimum capital adequacy, just to make sure that the funder is in a position to meet its obligations under its funding agreements. There is a prohibition on the funder controlling the conduct of the arbitration. As you will all be aware, one of the key concerns around funding generally is that the party may lose control of its own case and may be dictated to by the party providing the cash. And it's very clear that is not permitted in Hong Kong. Funders have to have adequate procedures for managing conflicts of interest and also complaints. Their liability, the extent of their liability, must be clearly set out in the funding agreement, and that includes whether or not the funder agrees to be liable for any adverse costs order that may be made against the funded party. And also the funder is obliged to remind the funded party that it can seek independent legal advice and that it must disclose the existence of the funding arrangement. One other thing to point out is that the Code of Conduct and the legislation apply to Hong Kong seated arbitrations, as you would expect, and also to work that's done in Hong Kong, even if the seat is outside Hong Kong. So, law firms in Hong Kong providing services and incurring costs for their clients in Hong Kong on, say, a Singapore or a London or a Paris seated arbitration. Alongside the Code of Conduct, the HKIAC introduced some new provisions when it updated the rules in 2018 to recognize and facilitate the new regime on third-party funding. Broadly speaking, the HKIAC rules on funding now require disclosure, so they back up the statutory requirement to disclose whether a case is funded. There is an exception to the rule on confidentiality, so that it is possible to share information about your arbitration for the purposes of basically seeking funding, but also letting the other parties and the tribunal and HKIAC know that you're funded. So that's all I really wanted to say about the regime in Hong Kong. It's from HKIAC's point of view, and I think from all of the stakeholders in Hong Kong's arbitration community, it's a good thing. I haven't heard any criticism or complaints personally about the introduction of funding. The concerns that existed seem to have been dealt with by the consultation process. And so we are now in a position where we are on an equal footing with the seats we principally compete with, Singapore, London, Paris, Geneva, the usual suspects in terms of seats. So just before I hand over to Cheng Yi, I wanted to quickly talk about what HKIAC has seen so far. And that can be, it's not been a huge flood, but I think that reflects the experience in Singapore as well, and in Hong Kong broadly beyond HKIAC's experience. The number of funded cases, so far HKIAC is aware of 4 funded arbitrations in its cases so far. You can see on the slide where the funded parties are coming from. And the one trend that HKIAC is spotting is that the funded claims tend to be big claims. You'll see there on the slide that the highest value claim was for best part of $750 million US. So we are likely to keep seeing, we think, these large claims coming through. As you'd expect, the funded party in 75% of the cases so far was a claimant. As I understand it, the one respondent who was funded at a later stage in the proceedings when it launched a significant counterclaim. In keeping with that trend, that the majority of funded parties will be claimant, 3 out of 4 of the funded cases were disclosed in the notice of arbitration, so funding had obviously been secured before the arbitration was commenced. That won't always be the case, but likely to be the majority of cases. And again, 3 out of the 4 cases were seated in Hong Kong, and the 4th in England. And if we can go back a slide, since I'm aware I skipped over one. Just a little bit more detail there for you. I won't go through it in too much detail, but of the HKIAC rules that reflect the funding regime. One other thing just to flag on that slide is the final point, which is that the tribunal may take into account any funding arrangement that's been disclosed when it's allocating the costs of the arbitration. So the things I'd like to leave you with are that funding is now fully up and running in Hong Kong. My understanding, and Omni can confirm this shortly, is that we're starting to see more cases come through. Of course, it's always worth remembering that what we see in terms of cases that are actually funded is a very small fraction of the cases where the parties are seeking funding, because it's a rigorous due diligence process that the funders do before they will agree to fund. So a lot of clients are exploring and actively exploring funding now, and we're starting to see those funded cases coming through. If you are involved in a funded case, if your client or you are the funded party, that must be disclosed, and it will be that needs to be done in writing for HKIAC's purposes. Okay, unless there are any questions on that side of things, I'm going to hand over to Cheng Yi, who's going to look specifically at the impact of COVID and what we've all lived through in the past 6 months or so on funding. Cheng Yi, can I pass over to you?
Thank you. Yes, Brianna. Thanks very much to Brianna for moderating this session, and also to HKIAC for hosting this webinar. We do have a good mix of disputes practitioners, in-house counsel, corporates, and academics in the audience today, not to mention a few competitors. So I'll try to refer to points of interest for everyone. Let's have a first, I'll start off with some comments on the impact of COVID-19 on third-party funding. It would be fair to say that funders have seen a significant spike in funding applications as the economic toll from COVID-19 has spread across business sectors. We have seen applications from a variety of sources, including public and private corporations and law firms looking to manage their cash flow and risk, and sometimes monetize awards and judgments. The number of inquiries for funding has roughly doubled globally compared to this time last year. This trend looks to continue into 2021 as the pandemic shows no signs of abating. So it's more important than ever that clients and counsel understand how third-party funding works and how it can assist during times of economic uncertainty. Now, dispute resolution finance is a potential source of liquidity. Now, why is this? On the one hand, businesses are facing a range of new commercial disputes, but on the other hand, many companies' budgets offer little room to pursue legal claims and seek recoveries that might sustain them through the economic downturn. Litigation or arbitration outcomes lie in the future and are inherently uncertain. A funder can help assess these outcomes, which is in itself a valuable service, and on that basis, provide a financing solution that lowers liquidity pressure using an asset that may otherwise be overlooked. Now, by using external funding to finance the costs of a dispute, legal claims can be leveraged as assets. This means that the funder pays some or all of the legal allowable costs in return for a share in the outcome. And in this way, businesses can improve liquidity, maintain cash on the balance sheet, and transfer all or a portion of the legal expenses to the funder. Some successful parties who are mindful of the backlog of cases and delays in the courts, as well as potentially deteriorating asset positions of award debtors, look to monetize their arbitral awards by selling them as a means of improving their cash flow in the short term, and or eliminating the risk involved in pursuing recalcitrant respondents through the courts. Funding is available not only for court or arbitration proceedings, including any related ADR procedures until an award or judgment is rendered, but is also available for enforcement of those awards and judgments and recovery of sums owed, as Marilyn will explain to you later on. Now, unlike traditional forms of finance, dispute resolution finance is non-recourse. This means that the funder receives a return on its investment only in the event of a successful recovery in the litigation or arbitration. if the case is lost, the funded costs or purchase price of the claim need not be repaid. However, if the claim is successful, the funded client can record the revenue without having incurred any downside costs or risk along the way, particularly when the funder is able to offer insurance to cover adverse costs. Now, most funders require funded parties to pay additional sums for external ATE or after the event insurance, which can be very costly. We're able to offer adverse costs cover to our clients at a very low cost because we are ourselves insured, and we're only seeking to recover part of the cost of our own insurance. So dispute resolution finance therefore helps to transform litigation or arbitration from an expense into a cash-generating asset. And the funding provides opportunities for substantial recoveries without negatively affecting profitability along the way. I mentioned earlier that funding applications have increased substantially as compared to the same period last year. However, while we're assessing more cases and ultimately funding more cases, the ratio of cases assessed for funding against the number actually funded has increased, as many applicants who are new to third-party funding do not understand the rigorous criteria that funders typically apply in reviewing a claim. Next slide, please. Now, I don't have time today to delve into our funding criteria, which you can see on this slide, and which will be similar for most funders. The information is available in a short 2-page guide in various languages that will soon be available on our new website, so you can look at them at your leisure. All of these criteria are equally important, but in the current COVID context, where companies' liquidities have been depleted, funders are especially mindful of whether a respondent will be capable of paying if and when the claims succeed. Caroline will give you an introduction to asset tracing and recovery specialists who can help identify where respondents' assets are located and develop a recovery strategy in appropriate jurisdictions. Next slide, please. I just want to pause briefly on this next slide to show those of you who are not so familiar with third-party funding, the kinds of claims that can be funded, depending on the jurisdiction, of course, and the kinds of funding available. I would say that the lesser known ones are corporate portfolio funding, where a business has more than one ongoing dispute, or law firm funding, where we provide funds to law firms to cover their overheads so that, for example, they can offer competitive salaries to retain the right staff. And I should add here that we can only do this in jurisdictions where contingency fees are permitted. You also have seed financing, where further work needs to be done by a law firm or a quantum expert, for example, to prove the viability of a claim. And thirdly, if a business requires working capital pending the resolution of the dispute, funders can also provide funding for their operations, provided there is sufficient margin in the expected recoveries from pending claims to fund such operational costs on top of legal costs. Now, if there is sufficient value in the claims in the portfolio, funders could potentially fund defenses. And as our risk would be diversified across a number of claims, we could offer funding at a lower cost per case. Next slide, please. A significant portion of funding applications received this year come from business interruptions caused by travel restrictions, shelter-in-place orders, and extended business closures as governments around the world strive to control the spread of COVID-19. The travel, leisure, hospitality, dining, and entertainment sectors have sustained significant damage, and it will come as no surprise that claims against insurers make up a good portion of these kinds of funding applications. Cash flow constraints have also given rise to claims across diverse industry sectors, ranging from technology to entertainment, as counterparties experience buyer's remorse in light of their economic changes from COVID and attempt to renege on their transactions. Some applicants are well-resourced corporates who want to demonstrate to their shareholders that they're pursuing claims in a prudent manner that gives up a portion of the upside, but eliminates risk. Parties have also sought funding for a variety of pending commercial disputes where COVID-related business and court disruptions have led to cash flow constraints. For example, many hearing and trial dates have been significantly delayed, resulting in delays in revenue for lawyers acting on large contingency fee arrangements. Likewise, a corporation that once had the ability to pay its law firm to pursue its arbitration and litigation claims may find that due to COVID-related revenue declines, it no longer has the cash available to see the arbitration or litigation through to completion without funding. Funding applications have also increased in relation to investment treaty arbitrations originating from multiple regions worldwide. Cash flow issues in industry sectors including energy, infrastructure, and natural resources may be causing aggrieved investors to consider initiating claims that were previously put to one side in favor of revenue-generating deals. Next slide, please. Now, this slide provides a snapshot of our global experience since we started funding insolvencies, impecunious parties, and enforcing judgments and awards involving distressed assets some 30 years ago. In Asia this year, we have received applications for all manner of commercial claims affected by cash flow issues, including insolvencies, and a growing number of applications for enforcement of awards and purchases of awards and judgments. Applicants have approached us from all over the world where their disputes involve an Asian element. This could be the applicable law, the seat of the arbitration, the arbitral institution involved, as well as the nationalities of the parties to the disputes and the location of projects. We are funding cases seated in multiple Asian jurisdictions, and many of them are based in Singapore and Hong Kong. COVID-19 has increased the risk of insolvency of parties on both sides of the dispute. This can prevent special challenges for funders evaluating disputes for investment, and it makes it important to select a funder with expertise and experience in matters involving insolvent parties or parties who may potentially become insolvent later down the line. Another risk is the time to resolution of funded parties that may take longer because, for example, proceedings are delayed, or it may be more difficult to collect from judgment debtors once you have a favorable award or judgment. Both are significant risks that should not be overlooked. And what you might consider a sort of no problem in collections type of respondent may no longer be the case, particularly if economies continue to suffer. Parties seeking funding should therefore do their research when selecting a funder to ensure that the funder has the financial resources to keep funding the claim despite delays and increased costs. And it would be a disaster if the funder could no longer meet its obligations under the funding agreement partway through the proceedings. So the last point I'd like to make is that parties must be able to collect sums owed to them. Otherwise, all they have is a very expensive piece of paper. And let me now pass over to Marjolein, who will talk to you about what collections on awards and judgments entail in our experience. Thank you.
Thank you very much, Jingy. So what I understand from the list of attendants in the audience today, we have many lawyers and arbitration practitioners who dealt with enforcement of judgment of arbitral awards in the past, but I also assume that not many of you may have dealt with a funder who actually assisted with the enforcement of arbitral awards of judgments. So I will kick off first with a case study to underline why the collectability of a claim is key and why enforceability should always be kept in mind. The next slide, please. Oh no, sorry, let's stay here for a while now, because what I would like to point out here is that getting an award is not the same as getting paid. And imagine having arbitrated for years and having spent over $2 million and finally winning an award of $12 million and then not be able to collect payment. And this is what happened to our UK client in a US arbitration case against a Nigerian counterparty. We were not involved in the arbitral proceedings until the award was rendered, but we were asked to assist with the enforcement. So the first check that we did was actually to assist first with the service of the documents in Lagos at the respondent's headquarters. So we asked our local contact to go there and assist with the service of the documents. And we got a picture of the headquarters of our respondent. And that you can see in the next slide, please. This empty plot and not actually the building being built in the back, was the headquarters of our client's counterparty. So it was quite clear, quite quickly, that the arbitration was a waste of money and time, and as Cheng-Yi said, unfortunately, just an expensive piece of paper. Collectability is always key, but fortunately, there are ways to make sure that you can collect your award, and there's ways to look out for that. As long as the counterparty or the respondent is able to pay and just evading payment, there's always a solution. Next slide, please. So our clients usually need the funding and management of enforcement actions for unpaid arbitration awards or judgments. So it's also possible to ask for funding or enforcement funding only and not to obtain the title. We can do both, so also fund the merits funding, but also just the enforcement funding. So we will offer funding and assistance pre-award or post-award. As Cheng-Yi already said, purchase of claims is also a possibility. And I would also like to briefly touch on our DARP project. That is a joint venture that we have with the International Finance Corporation of the World Bank for their distressed asset recovery program for the MENA banks. Our clients, the MENA banks, then send their non-performing loans to us, and we will assist with the enforcement of these non-performing loans. This is being done from our office in Dubai, but just means to show that we have been tested, not just by our clients, but also by the World Bank. And we don't just have extensive experience, but we also win. Next slide, please. The focus should always be on getting the highest possible amount in the shortest possible time. And we like to do that through various legal instruments. So these instruments are always a multifaceted strategy to create leverage on our counterparty or the respondent of our client. The first part of that strategy, and the most important part, if you will, is the asset enforcement. And we always try to get a focus on assets with a high attention value. And that is not the same as actually assets with a high value. For example, a high value, low attention value asset would be passive, non-strategic shareholdings. That can be just a nuisance if it's attached, but will not interfere with the actual running of the business of your counterparty. However, a low value, high impact asset can really be much more effective when you try to enforce. An example of that would be the apartment that was owned by our client's counterparty. It was a state-owned, the counterparty was a sovereign, and we managed to find an apartment in New York City that was owned by that sovereign. However, that apartment was used by the mistress of one of the decision makers of that sovereign. So when we tried to foreclose, we actually did get their attention, and we managed to settle the case quite quickly after that. So when I say that high attention value is more important than high value, I would also like to stress that I don't mean publicity, because publicity of a case usually works counterproductive. But other leverage can also be non-asset leverage. For example, effect on trade relations or financial ratings. Also the impact on other arbitrations, or also, for example, forcing the debtor to post security. Diplomacy can also assist, but it's usually not very effective and mostly used to bridge the last gap. It's also good to make sure that the actions are undertaken as much as possible across jurisdictions. For example, the sequencing of jurisdictions should be based on the arbitration friendliness or New York Convention friendliness, if you will, for recognition and enforcement of the awards. Ex parte versus inter-party jurisdiction should also be consideration. Will your counterparty be aware of the fact that you try to enforce, or can you do it without them letting them know? At least not at the moment when you try to actually garnish or attach. Time limitation considerations are also relevant because, for example, the prescription period in China is much shorter than, for example, in the Netherlands. So you have to really take that into account when you are starting with your enforcement measures and make sure that you can still do it in the jurisdictions where the assets are located. So we have a very long experience in dealing with debtors who are evading payment, and we have extensive databases and both public and our own proprietary to get the information that we need. And maybe it's good in the next slide to use it as an example, an asset that also had a very high attention value. So in this case, it was our client, a UK civil engineering company, who had a dispute with the Republic of Tanzania. Our client managed to obtain an award in the amount of almost $43 million. However, after winning the award, Tanzania decided to evade payment. So we assisted our client to try and get legal leverage outside of Tanzania and to create settlement momentum. So in this particular case, our investigation team, our internal team, managed to find out that our respondent had 3 airplanes built in a country outside of Tanzania. And we also found out that it was actually owned by our counterparty and not Tanzanian Airlines, even though they were meant for Tanzanian Airlines. And we also managed to find out that in the local regulations and the sovereign doctrine immunity, these planes were not subject to that immunity. So at the time that the government announced in the press that the planes were flying home, they discovered, to their much disappointment, that these planes were not going anywhere unless they paid the award. And that got their attention, and it actually also made that we could settle the claim for our client. Next slide, please. So assets are key. And it has to be assets that have true enforcement value and can withstand legal defenses, like sovereign immunity or corporate sovereign view, piercing the corporate view defenses. Assets have to be actually attributable to or owned by or held on behalf of the respondent. And like I said, if possible, high attention value. So allow me to briefly focus on what I will call the what, where, and how of asset tracing and enforcement. So what kind of assets can be enforced against? Well, there's over 100 kind of assets that are can be relevant, but the ones that spring to mind most quickly are the bank accounts. It's easy to enforce, it's easy to attach. However, also bear in mind, it's very easy to clear out a bank account. So even if you manage to find a bank account, also keep in mind that the money can be gone in a matter of seconds. So it's also good to focus on also other assets, for example, monetary flows, trade flows, but also one-offs. If you know that a shipment from your counterparty is going somewhere outside of its jurisdiction, it's worth the while. Hard assets like the planes, trains, and automobiles, real estate, but also assets held by other parties, third or even fourth parties. So where should these assets be? Well, preferably, of course, in New York Convention-friendly jurisdictions. But it's also good to take into account what is actually the legal system that's applicable. So civil law versus common law. Is it possible to attach prejudgment, or do you have to wait until you have an award or a judgment? Is it possible to ask for discovery? What is most relevant, though, is it should be properly functioning court, and you have to be aware of the prevailing doctrines on sovereign immunity and other. So how do you do that, and how do you find these assets? Well, as I already touched on briefly, we have our own internal asset trace team who assists with that. So when we are in the process of enforcing a judgment of an award, we always work together in a team to assist with that and to work on a strategy. We have our own, we plan the projects, and we source all our information inside and outside, and if necessary, we will ask the help of an external asset tracer, but more often than not, it's not necessary at all. What I like to, in a brief period of time, like to give, if you will, as a takeaway or a call to action, is just keep in mind, when you do initiate proceedings, already have the enforcement in mind. So this means check the asset position of your respondent and keep monitoring the asset position during the arbitral proceedings and until the title is obtained. This is especially relevant in these times where the financial situation of your counterparty can take a turn for the worse very, very quickly. It may be necessary to actually already undertake interim measures. So also look for assets that are based in locations where you can actually undertake these measures. But also, I think I would like to call out to the lawyers and the arbitration practitioners among you, please take good care when you request your statement of claims and your actual claim. Make sure to include all parties that you actually think or expect that you need to enforce against. So for example, did you think about the guarantors? Maybe you want to implicate the directors and the officers. And that's all fine, but make sure that you can actually enforce against them. And for arbitrators, I would like to ask them, please, when you think about drafting the dispositive part of the award, ensure that the award is clear and unambiguous and will not give rise to enforcement issues, at least not any enforcement issues that are caused by any ambiguity. I think the second takeaway that I would like to stress is that in these times when clients may be actually pressed for cash and they have that award lying about in their drawer and think that it's unenforceable or it appears to be unenforceable, we're more than happy to brainstorm with you and see what we can do. Because really, if your counterparty is able to pay and just not willing to pay, there is much more possible than you think. And this is relevant, especially in COVID time. It's to collect what is owed to you and your client. Well, unfortunately, we cannot meet in person quite soon, and it has to be by Zoom, but there's also other ways to get in touch. I mean, we're on LinkedIn. Chengi said we have a website, so please feel free to reach out to you. We're very excited to speak with you and brainstorm further. But for now, I really like to thank you all very much for your attention. Thanks.
Thanks very much, Chengi and Marjolein. Really interesting to hear sort of from the horse's mouth what's really happening and how it's working in practice, both with the virus and just before and after the virus in terms of enforcement. We have had a couple of questions come through via Zoom. So can I suggest that I start by putting those questions to you both, and then of course anybody who would like to is welcome to ask live questions after that, or keep them coming through on the Q&A, and I'd be happy to present them to Chengi and Marjolein. So Chengi, the first question we had through while you were speaking was around the industries you'd identified as being affected by increased disputes as a result of COVID. And the question is whether the shipping industry is also facing a similar increase in disputes.
Thanks, Brianna. Well, we do have applications relating to the shipping industry, but I wouldn't say that we've experienced a large increase in such applications so far, at least. They may start trickling in if the situation continues.
Okay, great, thanks. Yeah. And then the next question we had was a more general one, which is whether COVID has had an impact on funding agreements that were already in place before the virus hit.
Yes, so I can take a crack at that, Marjolein, if you like.
Yeah.
Okay, so it has had an impact on some funding arrangements. I would say in some funding arrangements, it has impacted the what we perceive to be the recoverability on certain respondents, but we have in each case been able to work around it to find a solution and to keep funding. Another thing that actually potentially positive impact of COVID is that we find that it's also perhaps motivated parties to try mediation, for example, or other forms of, amicable dispute resolution, perhaps earlier than before. So that's a good point.
That is interesting, actually. Be interesting.
Yeah.
Well, if I just may add to that, I think the only thing that may actually also influence a current funding arrangement, of course, if there's a really material adverse change, that may change it. And I think at least from an enforcement perspective, that will only be the case if the respondent or the counterparty really goes into liquidation, and it really appears that, like I said, they're not just evading payments, but they will just not be able to pay. But then again, I also would like to point out that the risk of that will just be ours, because we will only get paid when the money is in the bank. So even if we did win the arbitration and we started with the enforcement proceedings, and the financial position takes a turn for the worse, well, that is really sad. But that's also why we are keeping a very tight view on that.
Yeah, I think basically we would really not pull out of a funding arrangement. And this would be the nuclear option for us, because we would lose all our investment and remain on the hook for the adverse costs, as I mentioned earlier.
Thank you. Marielle, I'm just mindful of your reminder that you guys are experts in, particularly on the enforcement side, and that any party who's holding on to an award that they may think they can't enforce, or a party that's thinking about bringing a claim and is looking to the enforcement piece, as you quite rightly highlighted, they should all be doing. What are the right questions for them to be asking the funders when they are out looking for funding, or how can they access that assistance from you when assessing whether to bring a claim and whether to get funding for that claim?
Well, like I said before, we're always happy to look at a case, whatever. I mean, that's other than lawyers, it will be free of cost, and we're always looking for that. I would say, first of all, keep in mind, the sooner you come to us, the better, especially if you feel like it is relevant or urgent to take pre-judgment measures, pre-award measures. Other than that, when we look at it, if it's a merit funding combined with a possible enforcement issue, then of course we look at the viability of the claim on the merits, also on the budget, and that combined actually with the quantum of the case, because it has to make sense for all parties. Because what we do not want is take on a case, win the case, but that the cost will be so high, relevant to the budget, that there will not be any meaningful recovery for the client. So there's that. So we look at it as well. And then what we also always do when we're looking at a case, we are looking at the enforceability already immediately. So we take our investigation team, and they will actually do a preliminary asset trace and already come up with a preliminary strategy. And that we discuss also with our client. And like I said, so we just do not look only at the case of the merits, but also on the enforceability right away. And if we believe in that, then we're very happy to take it on.
Great, thank you. Cheng-Yi, you mentioned that you're seeing the virus possibly prompt parties to seek mediated settlements, or I guess negotiated settlements, a bit earlier than they might have. Do you see that as a continuing trend, or do you think that's very much going to be a COVID-related thing, and that as and when hopefully life goes back to normal, that parties may move away from that? And alongside that, I'd be interested to know what impact you're seeing in a mediation of the fact that the case is funded, because we will often hear people say that in contentious proceedings, once you've disclosed that your claim is funded, that can prompt people to settle because it's such a good endorsement of the merits of the claims for exactly the reasons that Mario-Line has just been describing, that it's a rigorous due diligence process and that the funder has to be persuaded of the merits and the enforceability before it will agree to fund. So just the fact that that the claim has made it through that process is often like a signal that it's a strong claim.
Right. So, sorry, that was quite a long question.
Sorry, that was a long question. So the short point is, how does the existence of funding impact the outcome in mediation for the funded party? And do you think the move to mediate is a COVID thing rather than a greater trend?
Right. Just so in relation to the first, your last question, as it were. Well, we actually like mediation. We like early settlements because it means we get our investment back earlier than later. So we hope that even after this pandemic passes one day, not too distant future, parties will be encouraged to continue to try and mediate their claims. I mean, it's a question of trying it, right? I think once you've tried it and it's been a good or productive process, hopefully parties will be more likely to try it again after that. And your first question, which was the impact of funding, right?
Yes, on
mediation,
outcome of mediation.
Outcomes of mediation. I hope we have a positive impact. We have been, I think, dealing with, the majority, I think about 80% of our successes to date since, I think, well, in terms of legacy IMF Bentham, pre the merger, 80% of our successes have been, good settlements. So I would hope that we have a positive impact on mediation. As you said, we don't control the settlements, but we do try and at least have a framework and agree with our clients ahead of time, what are the best ways in which to try and reach settlement, and realistic ways, especially, to reach settlement.
Great, thank you.
Yeah.
I've had one more question through Zoom from Jackie Fung asking, in respect of third-party funding costs and success fees, do you think that the English case of SR and Northcott will apply to arbitrations seated in Hong Kong under both sets of rules, the 2013 HKIAC rules and the 2018 HKIAC rules? And just to remind myself as much as everyone else, if I've remembered properly, SR and Northcott was the case in which the English High Court considered that the costs of funding were part of the costs of the arbitration and were therefore recoverable.
I think that would be very much up to each tribunal, wouldn't it? Whether it would take into account that ruling. I mean, certainly the HKIAC rules 2018, I believe, expressly permit tribunals to take into account third-party funding when they consider costs.
Absolutely.
Yeah. But I think it's hard for us to say yes or no, but I think it would just depend on the tribunal. I don't know, what do you think, Brianna? You probably have more to say on this.
No, I agree with that. That's not something I've thought about too much specifically, but I think that's probably right. I mean, my instinct would be that it's not a trend that's likely to be followed. I don't know if anyone else on the call has a view on that, that it's most likely to be not to be followed than followed, but as you say, it's impossible to give any kind of blanket answer.
It was very fact specific, wasn't it, that case?
Yes, as I understand, there were some conduct questions, weren't there?
That's right, yeah. I think the funded party was basically forced into seeking funding because of the conduct of the other side. And so that's the arbitrator found that it was right to impose costs.
Yeah, that's my understanding as well. Yeah. Fabulous. Okay, that has taken us to the end of, I think, to the end of the questions that we've had through Zoom. Oh no, so, well, actually this one I think has been covered already, but the question was, has there been any occasion where any funder withdrew funding for a case, and if so, on what grounds? Now, I'm guessing you may well not know the answer to that, but I'll throw it out there anyway.
Shall I take it? Yeah, I am not aware, but I would not be able to speak for other funders, but I'm not aware of any case. And I'm definitely not aware of any case that we have been handling that it happened. Like Ching-Yi already said, it would really be the nuclear option for us. And we actually, in fact, even though we like to solve cases as quickly as possible, there are some cases that we have been handling for 10 years, just because it's there, and also because we think and suspect that our counterparty will at some point have assets in a more friendly jurisdiction. So we just keep monitoring that. So I think, well, no, it is really, when we're in, we will be sticking with the client and with the case as much as we can.
Yeah,
I hope that answers that question.
As far as I know as well, we've never withdrawn funding for a case. We have a procedure in the funding agreement to deal with disputes as they arise, you know, but we've never actually had to use that to withdraw funding, as far as I know.
Good, that's encouraging. Okay, we've got just a few minutes left. Did anyone have a final question or two? I've got an eye on the chat, so if you'd prefer to send it in through Zoom, please do that.
Maybe while we're waiting, I could just perhaps make a point. A lot of the, well, not a lot, well, some of the inquiries that we've been getting are from parties who, you know, are in financial difficulties. They're not yet insolvent, but probably a question of time, I think, unless they manage to turn things around. So the only thing I would say is just don't hesitate to contact a funder. You know, don't wait until you're insolvent, because once the company goes insolvent, it makes things a lot more difficult, because then you have, you know, the liquidator, and then you have the creditors and all that. So, and as I said earlier, we can provide working capital to sustain a company pending the resolution of the dispute if there is enough value in that claim.
Great, okay, thank you. Okay, I think we have come to the end of both our questions and our time, so that's a happy coincidence. It's only left for me to thank Marie-Hélène and Cheng-Yi very much indeed for bringing their extensive expertise to the audience, and for answering the questions that have been put to them, and giving us such a good feel for exactly how funding works in practice, and most importantly, what to think about if you are interested in seeking funding. Thank you from me too to all of you for joining us. It's been a really impressive turnout. This session is being recorded, and I think I'm right in saying that it will be available on HKIAC's website shortly, so feel free to pass it on if anybody you know wanted to join and wasn't able to. And obviously you're welcome to contact me or Cheng-Yi or Marie-Hélène by email or via LinkedIn if you have questions or anything you'd like to discuss that you haven't had a chance to raise in this forum. So thank you very much again, and to HKIAC for providing the impetus and the platform to speak to you all today, and we look forward to seeing you at the next webinar. Thanks very much.
Thank you very much.
Thank you.